Thank you, Mr. Chairman. Chairman Dodd, Ranking Member Shelby, and members of the committee. I'm Fred Joseph, the Colorado Securities Commissioner and President of the North American Securities Administrators Association, NASAA. I'm honored to be here today to discuss legislative and regulatory changes that are most relevant to Main Street Americans who are looking to regulators and lawmakers to help them rebuild and safeguard their financial security. In November 2008, NASAA released its core principles for regulatory reform in financial services and subsequently issued a pro-investor legislative agenda for the 111th Congress. Today, I'd like to highlight the recommendations that we feel are most vital to sound regulatory reform and strong investor protection. NASAA's top legislative priority is to protect investors by preserving state securities regulatory and enforcement authority over those who offer investment advice and sell securities to their residents. Just one look at our enforcement data shows the effectiveness of state securities regulation. Last year in Colorado alone, my office conducted investigations that led to 246 enforcement actions resulting in $3 million ordered to return to investors and 434 years of prison time for fraudsters. And just last month, a Ponzi scheme investigation launched by my office resulted in a prison sentence of 132 years for the main perpetrator. And yet, over a number of years, there have been calls for preemption of state regulation and enforcement. The National Securities Market Improvement Act of 1996, NSMIA, preempted much of the state's regulatory authority for securities traded in national markets. Although it left state anti-fraud enforcement largely intact, it limited the state's ability to address fraud in its earliest stages before massive losses had been inflicted on investors. An example of this is the private offerings under Rule 506 of Regulation D. These offerings enjoy an exemption from registration for federal securities law, so they receive virtually no regulatory scrutiny. As a result, we've observed a significant rise in the number of offerings made pursuant to Rule 506 that are later discovered to be fraudulent. Although Congress preserved the state's authority to take enforcement action for fraud, this power is no substitute for a state's ability to scrutinize the offerings for signs of potential abuse and to ensure that disclosure is adequate before harm is done to investors. NASAA believes that the time has come for Congress to reinstate state regulatory oversight of all Rule 506 offerings. Next, the Madoff case illustrates the horrific consequences we face when an investment advisor's illegal activity goes undetected and unchecked for an extended period. NASAA recommends two changes to enhance the state's role in policing investment advisors. First, the SEC should expand the class of IAs that are subject to state registration oversight. In NSMIA, Congress provided that the states would regulate IAs with up to $25 million in assets under management, while the SEC would regulate the larger IAs. Congress further intended the SEC would periodically review this allocation of authority and adjust it appropriately. The time is now for the $25 million asset under management test to be increased, possibly to $100 million. Congress should also consider enhancing the state's enforcement authority over large IAs. Currently, a state can only take enforcement action against a federally registered investment advisor if it finds evidence of fraud. This authority should be broadened to encompass any violations under state law, including dishonest and unethical practices. This enhancement will not interfere with the SEC's exclusive authority to register and oversee the activities of large IAs. NASAA also urges Congress to apply the fiduciary duty to all financial professionals who give investment advice regarding securities, broker-dealers and investment advisors alike. This step will enhance investor protection, eliminate confusion, and even promote regulatory fairness by establishing conduct standards according to the nature of services provided, and not the licensing status of the provider. The fiduciary duty is obligation to place a client's interest first, to eliminate any conflicts of interest, and to make full and fair disclosure to clients. We recommend that Congress ratify the highest standard of care. For all financial professionals, the interests of the clients must come first at all times. Many observers believe that private actions are the principal means of redress for victims of securities fraud, but they also play an indispensable role in deterring fraud and complementing the enforcement efforts of government regulators and prosecutors. The problem is that Congress and the U.S. Supreme Court have restricted the ability of private plaintiffs to seek redress in court for securities fraud. These restrictions have not only reduced the compensation available to those who have been the victims of securities fraud, but they've also weakened a powerful deterrent against misconduct in our financial markets. Removing excessive restrictions on access to the courts would not only provide just compensation for investors, it would also benefit regulators by restoring a powerful deterrent against fraud and abuse, that is, the threat of civil liability. In conclusion, state securities regulators believe that enhancing our securities laws and regulations and ensuring they are being vigorously enforced is the key to restoring investor confidence in our markets. NASAA and its members are committed to working with the committee to ensure that the nation's financial services regulatory regime undergoes the important changes that are necessary to enhance Main Street investor protection, which state securities regulators have provided for nearly 100 years. Thank you very much.